Rule 75, Production of Will, Allowance of Will Necessary. Section 1, Allowance Necessary. Conclusive as to execution. No will shall pass either real or personal estate unless it is proved and allowed in the proper court. Subject to the right of appeal, such allowance of the will shall be conclusive as to its due execution. Section 2. Custodian of will to deliver. The person who has custody of a will shall, within 20 days after he knows of the death of the testator, deliver the will to the court having jurisdiction or to the executor named in the will. Section 3. Executor to present will and accept or refuse trust. A person named as executor in a will shall, within 20 days after he knows of the death of the testator, or within 20 days after he knows that he is named executor, if he obtains such knowledge after the death of the testator, present such will to the court having jurisdiction, unless the will has reached the court in any other manner, and shall within such period signify to the court in writing his acceptance of the trust or his refusal to accept it. Section 4. Custodian and executor subject to fine for neglect. A person who neglects any of the duties required in the two last preceding section without excuse satisfactory to the court shall be fined not exceeding 2,000 pesos. Section 5. Person retaining will may be committed. A person having custody of a will after the death of the testator who neglects without reasonable cause to deliver the same, when ordered so to do, to the court having jurisdiction, may be committed to prison and there kept until he delivers the will. Rule 76. Allowance or disallowance of will. Section 1. Who may petition for allowance of will? Any executor, devisee, or legatee named in the will or any other person interested in the estate may at any time after the death of the testator petition the court having jurisdiction to have the will allowed, whether the same be in his possession or not, or is lost or destroyed. Again, who may petition for allowance of a will? Any executor, devisee, or legatee named in a will or any other person interested in the estate may at any time after the death of the testator petition the court having jurisdiction to have the will allowed, whether the same be in his possession or not, or he is lost or destroyed. The testator himself may, during his lifetime, petition the court for the allowance of his will. Section 2. Contents of petition. A petition for the allowance of a will must show, so far as known to the petitioner, A. The jurisdictional facts, B. The names, age, and residences of the heirs, legatees, and devisees of the testator or decedent, C. The probable value and character of the property of the estate, D. The name of the person for whom letters are prayed, E. If the will has not been delivered to the court, the name of the person having custody of it. But no defect in the petition shall render void the allowance of the will or the issuance of letters, testamentary, or of administration with the will annexed. Section 3. Court to appoint time for proving will, notice thereof to be published. When a will is delivered to, or a petition for the allowance of a will is filed in, the court having jurisdiction, such court shall fix a time and place for proving the will when all concerned may appear to contest the allowance thereof, and shall cause notice of such time and place to be published 3 weeks successively, previous to the time appointed, in a newspaper of general circulation in the province. But no newspaper publication shall be made where the petition for probate has been filed by the testator himself. Section 4. Heirs, devisees, legatees, and executors to be notified by mail or personally. The court shall also cause copies of the notice of the time and place fixed for the proving the will to be addressed to the designated or other known heirs, legatees, and devisees of the testator resident in the Philippines at their places of residence, and deposited in the post office with the postage thereon, prepaid at least 20 days before the hearing, if such places of residence be known. A copy of the notice must in like manner be mailed to the person named as executor, if he not be a petitioner, also to any person named as co-executor not petitioning, if their places of residence be known. Personal service of copies of the notice of at least 10 days before the day of hearing shall be equivalent to mailing. If the testator asks for the allowance of his own will, notice shall be sent only to his compulsory heirs. Section 5. Proof of Proof at hearing. What sufficient in absence of contest. At the hearing, compliance with the provisions of the last two preceding sections must be shown before the introduction of testimony in support of the will. All such testimony shall be taken under oath and reduced to writing. If no person appears to contest the allowance of the will, the court may grant allowance thereof on the testimony of one of the subscribing witnesses only. If such witness testify that the will was executed as is required by law. In the case of a holographic will, it shall be necessary that at least one witness who knows the handwriting and signature of the testator explicitly declare that the signature are in handwriting of the testator. In the absence of any such competent witness, and if the court deem it necessary, expert testimony may be resorted to. Section 6. Proof of lost or destroyed will, certificate thereupon. No will shall be proved as a lost or destroyed will unless the execution or validity of the same be established and the will is proved to have been inexistent at the time of the death of the testator, or is shown to have been fraudulently and accidentally destroyed in the lifetime of the testator without his knowledge, nor unless its provision are clearly and distinctly proved by at least two credible witnesses. When a lost will is proved, the provisions thereof must be distinctly stated and certified by the judge, under the seal of the court, and the certificate must be filed and recorded as other wills are filed and recorded. Section 7. Proof when witness do not reside in province. If it appears at the time fixed for the hearing that none of the subscribing witness resides in the province, but that the deposition of one or more of them can be taken elsewhere, the court may, on motion, direct it to be taken and may be authorized a photographic copy of the will to be made and to be presented to the witness on his examination, who may be asked the same questions with respect to it and to the handwriting of the testator and others as would be pertinent and competent if the original will were present. Section 8. Proof when witnesses dead or insane or do not reside in the Philippines. If it appears at the time fixed for the hearing that subscribing witnesses are dead or insane, or that none of them resides in the Philippines, the court may admit the testimony of other witnesses to prove the sanity of the testator and the due executions of the will. And as evidence of the execution of the will, it may admit proof of the handwriting of the testator and of the subscribing witnesses or of any of them. Section 9. Grounds for disallowing will. The will shall be disallowed in any of the following cases. A. If not executed and attested as required by law. B. If the testator was insane or otherwise mentally incapable to make a will at the time of its execution. C. It was if it was executed under duress or the influence of fear or threats. D. If it was procured by undue and improper pressure and influence on the part of the beneficiary or of some other person for his benefit. E. If the signature of the testator was procured by fraud or trick, and he did not intend that the instrument should be his will at the time of fixing his signature thereto. Section 10. Contestant to file grounds of contest. Anyone appearing to contest the will must state in writing his grounds for opposing its allowance and serve a copy thereof on the petitioner and other parties interested in the estate. Section 11. Subscribing witness subscribing witnesses produced or accounted for will subscribing witnesses produced or accounted for were will contested. If the will is contested, all the subscribing witnesses and the notary in the case of wills executed under the Civil Code of the Philippines, if present in the Philippines and not insane, must be produced and examined. The death, absence, or insanity of any of them must be satisfactorily shown to the court. If all or some of such witnesses are present in the Philippines but outside the province where the will has been filed, their deposition must be taken. If any of If any or all of them testify against the due execution of the will or do not remember having attested to it or are otherwise of doubtful credibility, the will may nevertheless be allowed if the court is satisfied from the testimony or other witnesses and from all the evidence presented that the will was executed and attested in the manner required by law. If a holographic will is contested, the same shall be allowed if it at least three witnesses who know the handwriting of the testator explicitly declare that the will and the signature are in the handwriting of the testator. In the absence of any competent witness, and if the court deem it necessary, expert testimony may be resorted to. Section 12. Proof where testator petitions for allowance of holographic will. Where the testator himself petitions for the probate of his holographic will and no contest is filed, the fact that he affirms that the holographic will and the signature are in his own handwriting shall be sufficient evidence of the genuineness and due execution thereof. If the holographic will is contested, the burden of disproving the genuineness and due execution thereof shall be on the contestant. The testator may, in his turn, present such additional proof as may be necessary to rebut the evidence for the contestant. Section 13. Certificate of allowance attached to prove will to be recorded in the office of the Registry of Deeds. If the court is satisfied, upon proof taken and filed, that the will was duly executed and that the testator at the time of its execution was of sound and disposing mind and not acting under duress, menace, and undue influence or fraud, a certificate of its allowance signed by the judge, and attested by the seal of the court, shall be attached to the will and certificate filed and recorded by the clerk, attested copies of the will, devising real estate, and of certificate of allowance thereof, shall be recorded in the register of deeds of the province in which the lands lie.